The cases examined have all shown different facets of the late 18th century legal system. They have shown that madness as testified by witnesses was an adequate reason to get a defendant acquitted. They have shown that the character of the defendant was of the utmost importance, and they have shown that in trials where there was not enough evidence the charge had to be proved in a narrowly defined set of parameters, that is, it had to be proved that the defendant was guilty of the charge brought against him and nothing else, and if any other charges are proved incidentally that is of no concern. Above all, they have shown a legal system different from our own, that had to rely heavily upon witness testimony in ascertaining the facts of the case, and when science is used, it is more often than not the nascent medical science of the late 18th century. It has provided an insight into the workings of the court in the late 18th century, specifically the workings of the acquittal system. The reasons that a defendant could be acquitted have been the primary concern, and the implications of this the reliance upon witnesses and surgeons. The court in the late 18th century was one of contradiction. The charges had to be proved beyond doubt, and yet there was not sufficient means to achieve this level of certainty. So, what we have is a legal system that must use the tools it has in order to prove the charge as firmly as possible while, ultimately, being unable to do so.